Good afternoon, and for those on the West Coast, good morning. I'm Chris Larus, Chair of the Minneapolis-based IP and Technology Practice at Robbins Kaplan. And I'd like to welcome you to the first of our two-part series of webinars on best practices in a transforming patent environment. Today's first webinar in the series will address evolving strategies for patent procurement. This webinar series will offer a combination of perspectives on how innovative companies can most effectively adapt their approaches to patent procurement, licensing, and enforcement to maximize value. Our presenters today are myself with Robbins Kaplan. Robbins Kaplan is one of the country's premier trial firms with over 230 lawyers and offices around the country. We're focused solely on representing clients in disputes before federal and state courts, arbitration tribunals, and in administrative proceedings before the Patent Trial and Appeal Board. For the past 25 years, I've represented innovative technology companies in a variety of patent, trade secret, trademark, copyright, and licensing disputes, and related licensing campaigns. With me today is my friend and colleague, Tim Bianchi. Tim is a principal with the Schwegman, Lundberg, and Woessner firm. The Schwegman firm is dedicated to the procurement and management of patent rights for its clients, both domestically and internationally. Tim has been procuring patent rights for technology clients for the past 24 years, but is also engaged in post-grant reviews and supporting litigation teams on patent issues. Before we get started today with the presentation, a few housekeeping notes. First, our live chat window can be found on the lower left-hand corner of your screen. Please feel free to submit questions through this window, which we will address either during the presentation or at the end of the presentation. A copy of the presentation slide deck and speaker information can also be found at the lower right-hand corner of your screen. An on-demand recording of today's webinar will be available 1 to 2 days after broadcast. And finally, some CLE information. This course is pending approval by the Minnesota State Board of Continuing Legal Education for 1 hour of general CLE credits, and you'll be notified once approval of that credit is confirmed. Now to move on to our presentation. Those of us who are involved in the patent practice, whether in procurement, portfolio management, licensing, or enforcement, are certainly aware that we exist in a rapidly transforming environment for all aspects of patent practice. And if we look back only in the last few years, we see the substantial changes in the way the practice operates. Certainly the existence of IPRs and other post-grant proceedings that were enabled by the American Invents Act have substantially transformed the practice. Challenges to patent-eligible subject matter under Section 101 of the Patent Act and ALICE have similarly substantially transformed enforcement efforts and have greatly impacted the value of certain types of technologies that are subject to patent protection. And increasingly, these types of challenges to patent-eligible subject matter are seen at initial pleading stages, which has great impact in the way in which patent enforcement proceedings progress. We've seen changes in the standard for definiteness through the Supreme Court's decision in Nautilus versus Biosig Instruments in a way that has raised the bar for patent holders. Also, very fundamentally, we've seen substantial changes in the law governing the calculation of patent damages and the increasingly stringent demands of the Federal Circuit for presentation of econometric evidence supporting a reasonable royalty that's based on the specific incremental value that an invention brings to a product. And overarching all of this, dating back to the Supreme Court's decision in eBay, is increased difficulty in obtaining injunctive relief to exclude others from practicing the invention. Each of these topics could be the subject of a seminar that would last more than an hour in and of itself, but our focus today is to talk about, not about these changes per se, but talk about the evolving strategies of how innovative companies and patent holders should adapt their best practices to drive value in this rapidly changing environment. As we address these strategic issues, it's helpful to level set and go back to understand again the economic ways in which patents do drive value. How do companies realize returns on their R&D? Certainly, the key right that one obtains through patent prosecution is the right to exclude a competitor from the market to protect premiums arising from the patented technology. Other ways in which patent holders can derive returns and drive value are through generating royalties from licensing, either as a means of increasing revenue in and of itself or as a means of protecting market share by impacting the cost basis for competitors. Certainly, we see many patent holders who focus primarily on using patents as a defensive shield to disincentivize infringement assertions by others. And then there are other companies that generate substantial revenue from sales of non-core patents or from patent portfolios as a whole. Significantly, each of these models, these business models for how to drive value from patents, ultimately require and rely upon a credible enforcement threat as a way of actually realizing value. And increased uncertainty decreases the patent value and decreases the return that can be realized through the investment made in R&D and a patent portfolio. So in light of that increased uncertainty and all of the changes that we've talked about, certainly there has been a change in focus in terms of how patent portfolios are evaluated for prosecution and procurement, licensing, or acquisition. And this is true whether it's the evaluation that we undertake when trying to work with clients to identify which parts of a portfolio are good candidates for a licensing campaign or potential enforcement. And they're all, and perhaps more importantly, the focus has changed with respect to the entities that are providing funding for potential enforcements, whether that's internal corporate funding or it's external capital sources that often get involved in funding patent enforcement and monetization campaigns. So how has that focus changed? What are the attributes of a patent portfolio that that those types of investors or folks evaluating a portfolio, whether prosecution, maintenance, or acquisition, what are they looking for? Certainly, a clarity of claims and descriptions of the claimed invention, absolutely critical. Demonstrable infringement. A high-value infringing market, one in which premiums are obtained through the patented invention, tied to a credible damage calculation. Certainly, no apparent validity flaws. And as we'll talk about later, this is with a particular focus on Section 101 and patentability laws that might impact adversely the value of the portfolio. Increasingly, portfolio size and geographic scope are key concerns, as are the availability of open prosecution and the ability through continued prosecution to address either prior art challenges or other types of challenges brought to the validity of the patent. Strategic prosecution can impact each of these key value drivers, and I'm going to expand on some of them as we move through our presentation. Clarity of claims and descriptions. Why does this matter? Well, certainly as a fundamental threshold, few will invest in an enforcement effort or take a license if they cannot understand the patent and the nature of the risk that it presents. Clarity ultimately reduces risk, and that's manifested in a number of ways, including the risk associated with claim construction and validity challenges to the patent. And I often encourage those who are involved in patent procurement to think about the clarity of claims and descriptions in terms of providing tools to litigators and license negotiators who are ultimately going to be tasked with the obligation to communicate the invention and its relative importance, whether to a licensing target, a judge, or ultimately a jury. In the vein of clarity of claims and description, it's critical to consider the technical benefits of the invention that will ultimately be the subject matter of any damage claim, and how those technical benefits are described and articulated in the specification. It's critical that they be articulated clearly, again, with an eye towards providing negotiators and litigators the ability to communicate most effectively. Regardless of what types of collateral messaging will go around the patent, ultimately a licensing target or the recipient of a demand and an enforcement effort will focus very heavily on the patent and how the benefits of the invention are claimed and described in the specification. Similarly, the claim should be tailored to capture those benefits. The incremental benefit of the invention that forms the basis of the damage claim or the valuation in a licensing negotiation, it should certainly be the ones that are carefully claimed in the tailored claim section, not just referenced in the specification. A careful description of the benefits can give some protection against validity and claim construction challenges. And certainly as you undertake to explain those benefits of the invention throughout the specification, there should be a focus on those benefits that can be quantified, because that's ultimately the challenge that will result in a license negotiation or an enforcement effort. Demonstrable infringement is certainly a key attribute of any portfolio under evaluation. And it's critical that those involved in procurement of patent avoid claiming strategies that can reduce value. One such claiming strategy that we see often are claims that are directed only to direct infringement by ultimate end users who are not competitors or key market participants. Those types of claims can substantially reduce the value of the ultimate claim if it's required that in addition to demonstrating infringement by end users, the actual value and financial benefits of the invention are derived by someone else within the chain, such that it's necessary to pursue claims for induced infringement or contributory infringement. A key risk point around claiming strategies that reduce value is the risk of joint or split infringement. This is particularly important when we're talking about network-based inventions in which certain steps in a claimed method or certain apparatus aspects of an overall claimed apparatus are owned by different parties or operated by different parties in the supply chain. Another claiming strategy that can reduce value is claiming the system in too large of a way, taking in components that are not essential to the nature of the claimed invention and the innovative step claimed in the patent, can complicate the infringement picture and ultimately challenge the ability to demonstrate the incremental value of the invention. In contrast, there are a number of claiming strategies that can help to drive substantial value. One is considering whether the claims are drafted in a way to avoid potential marking requirements. I'll talk about that in a moment. Certainly drafting claims to capture the highest value direct infringers and capturing direct competitors of the patent holder. Keeping in mind the supply chain and the economic structure of the market in which the patent holder competes. Does the patent articulate and describe quantifiable benefits of the invention versus prior alternatives? While there's often reticence to make those types of comparisons of improvements over the prior art explicit in the specification, it can be an important factor in demonstrating the incremental value of the invention to a licensing partner or in potential enforcement. I'm going to talk for a moment about considering damage period, expand a little bit on the issue of drafting claims with damages in mind. Claims provide a lot of information about the potential damage period, and obviously for apparatus claims, a failure to mark can cut off the damage period in many cases, or limit the availability of damages, especially if there's an apparatus claim that is not being practiced by the patent holder. On the other hand, if only method claims are asserted in litigation, the marking restriction of Section 287 won't apply generally. So this puts a premium on the importance of making sure that there are parallel method claims that cover the practice of technology utilizing a claimed apparatus or otherwise articulating a method claim as a way of driving additional value, especially in instances in which the patent holder does not itself practice the invention. And as I said before, certainly when looking at method claims, it's critical to look at to ensure that they are drafted in such a way that they capture the actions of the high value link in the supply chain. Is the claimed method capturing the actions of a direct competitor to the patent holder or others who are in fact practicing the highest value in the chain, as opposed to lower, more commoditized suppliers within the chain or end users who are not key financial participants in the market. I'll circle back then to two other points before I turn it over to my colleague Tim, in the way in which portfolios are evaluated and how that's changed. And that relates to the topic of portfolio size and geographic scope. Increasingly, for reasons that we'll talk about, and especially relating to IPRs and other post-grant challenges, there's an increased emphasis on the overall size of the portfolio rather than focusing on having one key patent that covers all aspect of an innovative technology, or a small, closely related portfolio of patents. Increasingly, there is greater than additive value to having a portfolio that incorporates multiple independent families of patents, so that if one of those family members is successfully challenged, others will still stand and can be used for enforcement and licensing purposes. Similarly, there's an increased emphasis on geographic scope. While investors in patent enforcement continue to see the United States market and the United States courts as the prime drivers of damage recovery, the increasingly challenging standard to obtain exclusion of the market, to obtain injunctive relief, does place an emphasis for many types of portfolios on geographic scope, covering other geographic markets where injunctive relief is more readily obtainable. Certainly Germany is one of those that has a long-standing reputation as being a market in which injunctive relief is readily available. And interestingly, the China market, courts in China are increasingly seen as being favorable to granting injunctive relief to patent holders. That type of, the availability of that expanded geographic scope for coverage can be a helpful value driver in looking for and evaluating patent portfolios that go beyond the U.S. market. And very similarly to the issue about the size of portfolios is the availability of open prosecution. Increasingly, there is a focus on the importance of having continued prosecution as a way of impacting risk and limiting risk to patent holders. And I'll talk in the next phase of this presentation on some strategies that patent holders can implement when they are managing portfolios in order to effectively and efficiently decide which patents to maintain open continuations on or continue prosecution. But with that, I'm going to turn it over to my colleague, Tim, who's going to talk about effects of the transformations on patent prosecution particularly.
Thank you, Chris. Appreciate it. So we have seen a lot of change. I sat back and I just took a little bit of a inventory of what has been going on for the last decade. And not the greatest with dates, so I have to look these things up. So what I noted is that, KSR versus Teleflex was decided April 30th, 2007 by the Supreme Court. That's roughly 10 years ago. I don't know where all those 10 years went, but they sure went quickly. But what you have here is decisions that have come upon us. We went from an environment where patent eligibility back in 2007 was, pretty much assumed for software and business method and medical diagnostic patents. It was just in play. And to now, we compare what we have learned from the Alice Mayo Prometheus decisions and the progeny from those and the pushback on 101. So we're in a very different world from a patent prosecutor's perspective in terms of both obviousness under KSR and 101, although the obviousness under KSR is a little more pronounced, I think, in the post-grant proceedings, and I will talk a little bit about that. Not to mention the AIA happening and shifting from a first to invent system to a first inventor to file system. That's a big change. And we've seen the rise of administrative validity challenges occurring over this last decade. So there's been a lot going on. And what I want to do is just take a few notes of what we have experienced and what we've learned. And I want to talk a little bit about, for example, in patent eligibility. We all know that the case law that's coming out from the Federal Circuit has been challenging at times. And we even have jurists and practitioners admitting that there are murky standards that have developed for Section 101 challenges. And so we're living in that world right now. And what we're seeing is the occasional decision that is pro-patent, patent owner, pro reversal of the 101 rejection. And practitioners, especially in prosecution, are looking at those very carefully to try to see what can we do to match our fact patterns to those 101 decisions that have made it through the sieve. As I talk to different practitioners, I know that there's a very varied experience in 101. Some practices are hardly impacted by 101, and some are probably devastated by 101 at this time. And so depending on who you're talking to and what client they're working for these days, you get quite a varied outcome and quite a varied approach in prosecution. So not one size will fit all in this discussion, but generally what you're seeing is practitioners, especially in the software arts, are working very hard to try to match their patent applications and their fact patterns to those of the cases that have made it through the 101 filter. And the way that that's done, of course, is to make sure also that you have adequate hardware realizations described in your patent applications, lest you be held to be abstract and have very little on the hardware side to fall back on for purposes of amendment during ex parte prosecution. So I think the one takeaway, though, I'd like the audience to have from this, though, is to have some hope that this is moderating. I think that the 101 pendulum is coming back our way. I'm not sure it'll ever be where it was a decade ago, and I'm not sure it should be back that far either, because I mean we have some business method patents out there that are a little bit, you have to blush a little bit when you see what was issued in the day. But at the end of the day, I think what we're going to see is a retreat from some of this more aggressive anti patent 101 rejection status, especially in prosecution. And I think that we're seeing filers that are filing despite the kind of heavy pushback on 101, because I think everybody intuitively believes that the current law as it is right now is not really workable and that it's going to have to moderate. So I think we can be hopeful about that. I'm going to move on to obviousness. I think obviousness is kind of a tricky little uh, uh, issue because it really relates to the IPR and post-grant challenges piece of our discussion. Um, KSR kind of got uh, slid under the carpet there, and it did an enormous amount of impact to the patent, the ex parte prosecution practice when it first came out. In those first few years, examiners were using KSR uh, with great ease to try to put things in rejections, and they were stalling and slowing down that prosecution. And the backlog of those cases that went up on ex parte prosecution appeal was fantastic, and we started seeing some real heavy docket loads at the BPAI, now the PTAB. But obviousness, I think, has moderated in ex parte prosecution. It's not quite as hard to get cases through in ex parte prosecution as it originally was with KSR. Where it's really coming out to be a challenge, I think, are in the IPR. It's the post-grant arena, IPR, some ex parte patent appeals because the board is besieged with them and they're being a little more quick to dispose of those cases, and re-exam. So in those areas of post-grant review or ex parte patent appeals, I think KSR obviousness is still a challenge, and parties will still try to tee up secondary considerations, and the board has been granting more cases in favor of patent owners than before on those things, but it's still a pretty uphill battle. So it's an interesting change of events that we've seen there.
So Tim, we have a question from Troy P. Relating specifically to obviousness and to issues about descriptions of benefits in the specification. And Troy's question is, I try to avoid describing benefits in the specification as much as possible because the examiner too often uses that material as the basis for 2020 hindsight obviousness rejections. I wonder if you can address how you see that in changing strategies around procurement.
It's a very astute observation. We do run into those kinds of issues. You do have to try to push back on the examiners when they start to do that, because really what it comes down to is a form of taking the specification itself to make the rejection, which is in itself objectionable. Okay. The other piece is that to be more, when you're drafting patent applications that have to make it through both European practice and US practice, problem solution is the way to go. I mean, the Europeans are absolutely intent on knowing what problems you are solving, and they will be steadfast in rejecting cases where problems and solutions are not well established. And I think, as you mentioned earlier, Chris, is an excellent point, is that a lot of our practice is shifting towards an outside the US kind of practice. I mean, we're talking about enforcement actions in Europe today that were just not contemplated a decade ago. It just didn't happen. And so to be patent ready, you have to be able to work in various different jurisdictions and countries, and problem solution is the call of the day for Europe. And so you have to push back on the examiners on those things, and you have to be steadfast and cite your case law that precludes the examiner from using your own disclosure against you. So I think that's enough on obviousness. Just want to shift over to IPRs, because obviousness and IPRs to me are kind of the same issue. What happened overnight is the American Invents Act comes in, and that's, we're talking 2011 with the institution of IPR at the end of 2012, September of 2012. But it's a relatively recent thing. And what happened is the KSR obviousness piece had already supercharged inter partes re-exam. If you look at a table a chart where you look at the number of filings of inter-parties re-exams, and I'm not talking about AIA trials now, I'm talking about the old school IP inter-parties re-examination. Um, those those re-exams were not even used, and probably due to the estoppel and fear of the estoppel, for a good part of the first few years of that statute. That they came into effect and really started moving on and up in numbers after KSR. KSR supercharged post-grant, really, frankly. And so at the end of the day, uh, that system wasn't working because it was so inefficient. So we did adopt these proceedings called IPRs, PGRs, and CBMs. And the reason why petitioners love them is because they don't have to worry about the presumption of validity. I mean, they're looking at a broadest reasonable interpretation, which broadens the claim scope, and they're looking at preponderance of the evidence, burden of proof standards. So what's there not to like in those things? What IPR practice is doing, though, is when you put a three-judge panel of basically patent attorneys that are reviewing a patent, and you're looking at parties that are spending, probably on the order of 10 to 15 times the cost of a patent application to, in the case of petitioner, to shoot it down, in the case of patent owner, to try to prop it up. You're seeing a whole lot of, frankly, great patent work being done on the front end of these administrative proceedings, both by petitioner and patent owner. I think it's fair to say. So these proceedings are actually bringing out some really interesting things. But what it does do is it kind of exposes sketchy prosecution, let's just say. Um, and so, it's a high stakes game because usually a company isn't going to invest six figures to try to knock out a patent that it isn't threatened by. And it's even higher stakes for patent owner because motions to amend those patents are almost never granted by the board. We keep hearing that that's going to change, and it could. So I just want to note that we reserve the right to change our opinion on that. But for right now, it's high stakes for patent owners too, because what you have on that claim set, and we're talking in the absence of, I'm not talking about continuation practice or anything like that, but what you have in that current issued claim set that's under challenge, that's pretty much what you have to work with. So it is high stakes for those patent owners. So um, these AIA post-grant proceedings are really kind of an interesting new feedback for patent prosecutors. And by the way, they're actually good feedback for examiners too. And the patent office is looking at that as well. And hopefully what we're going to see over time is that these proceedings actually reward good drafters, good patent practices, and deter not so well drafted patent practices. So what are those? Let's talk about those a little bit. Your time is limited, so I'm just going to take a few high points of what we've learned from the post-grant practice. And I think my first point is that, I don't think there's any big headline to say that what you've written in both preparation of patent applications and in prosecution of them will be used against you in a court of law. I mean, that's not, in itself, that is nothing novel. But what we're seeing, though, is that what we saw early in post-grant practice is that practitioners were thinking, well, under broadest reasonable interpretation doctrine, I'm more concerned about what the specification says, like a la Phillips, than I am about what we say in prosecution, because those arguments are more along the lines of a Phillips construction relegated to district court. It has become abundantly clear that that is not the case. We have both case law, cited Microsoft versus Proxicon. Sorry for the eye chart here. I know this is small print, but I thought it might be nice to have some notes to refer to later when you're going back over the materials. Microsoft versus Proxicon explicitly states that the prosecution history is to be used for purposes of the BRI. And so, and that whole mindset is adopted by the latest guidelines and amendments to rules of practice by the PTAB. They explicitly state that the relevant prosecution history should be considered when you're doing claim construction, as long as it's specifically cited, explained, and relied on upon by the parties. So we are in a world where what you say as a prosecutor is really up on deck as soon as those patents go into inter parties review or post-grant review or covered business method review. And that can happen really quickly, as we all know. So what you're really doing as a patent prosecutor is you're not just controlling your claim constructions, you're controlling your BRI all through the proceedings and even post-grant, because those comments that you make, whether they're in the original ex parte prosecution record or in the post-grant records that are developed, like say, for example, an ex parte re-exam, they impact the scope of your patent. And they do it in a relatively quickly sense when it comes to these AIA patent trials. So the past practices that avoided discussion of the prior art and avoided the discussion of the invention are up for potential review and reconsideration now, because um, these are tactics for getting your patent claims into a reasonable, broadest reasonable construction, not just a broad construction. Okay, that's lesson one. We got to rethink what we admit on the record, both in the patent application itself and in prosecution. Lesson two is, practitioners have in the past taken great liberties with priority claiming, priority documents. And a lot of times examiners don't have the kind of time to sift through priority documents and find out if those claims are supported or not. And as a result, these things can be kind of ticking time bombs in file prosecution histories, because what you have is a situation where you have, let's say, a provisional filed on date A and a non-provisional filed claiming the benefit of it on date B with different subject matter. I mean, you have a potential time bomb of any intervening prior art that could show up and uh, perhaps provide a prior art basis that looks on the face of it to be predated by the provisional, but in fact is not. And parties will scour these file histories and will look for those things, and the board does pay attention to these arguments. So they do get amplified. It gets even more exaggerated when you're talking about continuation in par practice vis-a-vis an earlier parent filing, because you can have much more than a 1-year gap in priority dates. And that's also assuming new matter. I mean, you can actually have claims that exceed the scope of your application even in a straight continuation context and raise problems. And these things are showing up in post-grant. So we have to be careful of that. So our practice tips on there is can't really let off the details. You have to, as a patent practitioner, you still have to keep on full strength. The next points are more just observations than they are real hard life lessons. The board is still looking at indefiniteness issues explicitly in CBM and PGR. Not in IPR, it comes up in the form of a board that can't construe a claim and has to dismiss the proceeding, which is going to be very hard on any patent owner that tries to enforce the patent. Means plus function with Williamson, we're all on deck with that for trying to figure out how to control our functional claiming aspects of our claim elements to make sure that we're not getting into 112 paragraph F by accident, or in case you intend it, to try to clearly and more expressly claim those things and make sure you have support in the specification. And we're also seeing, for all you prosecutors out there that are filling out 1449 forms and information disclosure forms diligently, you want to be very careful about if you've had parallel IPR proceedings, because we're seeing a rise in the assertion of parallel IPR proceedings, because we're seeing a rise in the assertion of inequitable conduct claims as a result of failure of firms to adequately disclose under Rule 56. So that's a growing area of concern. And these are voluminous files. These IPR proceedings and CVRs and PGRs, they can be quite a bit of information. So you have to really think twice about your 1449 duties. I'm running down on time, so I'm going to make this next section roll very quickly, but I'm just gonna cut to the chase. I mean, with IPR, for all you patent managers that have your patent portfolio guidelines out there that have been established, you want to really revisit those patent filing guidelines and see if they still work in view of IPR. And what do I mean by that? What I mean is that in almost every portfolio, you cannot afford to gold plate every patent application. Just the costs are just not they're just prohibitive in most companies. If you can, great. Then you can skip this whole next 2 minutes I'm going to talk about. If you can't, and you're like most of us mortal human beings who have to deal with budgets and people with Excel spreadsheets, you want to basically try to figure out how to separate your inventions from the high stakes ones versus the more lower stakes ones. And so those pioneering inventions that you think are going to add margin to your bottom line, I suggest that you consider them in your portfolio, your guidelines for patent filing as a special case and up those budgets not only for patent drafting but for patent search and for even response practice if it need be, because nothing beats well-drafted, scoped patent applications that result in patents that are well-crafted to try to get through the IPR issue or avoid it completely. And it usually involves a lot more knowledge of prior art than practitioners are held to have. It also involves more claims, things like that. So the first step is to sort those things and try to separate your pioneering from incremental. We just showed, just for an interest of the we went back to 2007, and your iPhone 1 is basically on your left side. That was pioneering in its day because of the touch keypads and displays and things like that. Now we have iPhone 7s, and we're all, those features that are changing are more on the incremental side, although they can be still big dollars. So the next slides are just about how to differentiate your pioneering and incremental inventions, and I laid down some aspects of both so that you can have some guidance on which is which. And of course, the next step of the process is just to allocate resources accordingly. So if you have high stakes or pioneering patents, you need something more than just the run-of-the-mill patent prosecution budgets. So that's really it. And the last point I wanted to make on this methodology for managing your patent portfolios is you're going to have to go back and you're going to have to just do a reality check to make sure that those bigger budgets are on the right patent applications and patents, and that you're valuing your portfolio accordingly. With that, I think what I'm going to do.
Great. Thanks, Tim. So the last topic that we're going to
to
talk about today is our challenges relating to the management of patent portfolios and how to make sure that in this very fast change of patent portfolios and how to make sure that in this very fast changing environment, those who are in-house or otherwise tasked with managing portfolio budgets are doing so in a way that actually drive the greatest value out of the portfolio. And this is probably one of the biggest challenges that in-house lawyers have who are tasked with managing, trying to figure out which are the applications to vigorously pursue, which are the issued patents to maintain as we work with increasingly constrained budgets in many situations. Historically, decisions about which patents to maintain tends to be a very internally driven exercise, with a great deal of focus upon whether or not the patent covers technology that's being practiced by the company or is otherwise seen as being core to the company's business strategies. But in light of this changing environment, I'm going to suggest that there are some additional considerations that many innovative companies are implementing as part of their best practices to make sure that they are maintaining and cultivating their portfolios in a way that really drives maximum value. And in this topic, I'm going to talk about three things. First of all, the increased importance of portfolio size and geographic scope. And as I talked about earlier, size matters. And it's critical to consider that the impact of independent families and independent patents in any enforcement effort. Secondly, I'm going to talk about the increased importance of open prosecution. And finally, I'm going to touch briefly on the use of patent analytics as a way to determine which patents to maintain. So Tim did an excellent job of describing qualitatively some of the considerations that, that go into IPR practice and how those involved in procurement and maintaining portfolios need to consider best practices from a qualitative standpoint in terms of IPR practice. But as we're considering the importance of portfolio size, I think some basic statistics are helpful to paint what is actually a very stark picture for patent holders. The first statistic is if we look simply at statistical information about IPRs that have gone through a final written decision. And we look at the last year for which we have information, which was released in 2016 and runs basically through fiscal year 2015. So this is looking at essentially the first 3 years of IPR data. We see that 72% of the time across all technologies, all patent holder sizes, and all types of patents, where a petition is filed, an IPR is actually instituted. So the bar for institution is relatively low, and the risk that is posed to an IPR of an IPR proceeding, even for companies that are pursuing best practices in their prosecution, is very high. The risk that there will be an IPR instituted in any case in which there is an enforcement or substantial licensing effort is very high, with 72% of the time these petitions being granted. But the story doesn't get any better for patent holders when we look at the results of those IPR proceedings. And what we see is, again, looking at that same across all technologies, all patent holder types, we see that in a vast majority of time, in fact, only 28% of the time, where an IPR petition is instituted and goes to final written decision, has at least one claim survived. All of the rest of the time, all claims that are challenged end up getting canceled. So that helps to demonstrate the gauntlet that patent holders have to run when they are pursuing a patent enforcement or high-value patent licensing negotiation. These present a very effective way for a target of an enforcement effort to challenge the validity of the patent, and the win rates for those challengers are very high. The net result of this is that best practices really weigh heavily in favor of having a broad and diverse portfolio of patents that discreetly claim independent aspects of an invention or patented technology, rather than focusing on the idea that there's going to be one single patent or small portfolio that's going to capture the entirety of the value of the patented technology. Size matters. The size of the portfolio and the number of patents that can be brought to bear in any enforcement effort has an enormous impact on the value of that portfolio. And it's much more than simply additive. So as we evaluate patents for potential enforcement campaigns, or as we work with companies that in many cases are making investments in supporting those enforcement campaigns, there's a very outsized importance that's being placed on the size of the portfolio and the number of independent families involved, as well as issues around geographic scope that we talked about. So now I'm going to transition to the topic of using patent analytics. And again, oftentimes the decision about which patents to maintain is a very inwardly focused decision. But increasingly, clients that we work with are using analytic, objective, statistical data to make the determinations about which patents to maintain and which patents to continue in prosecution in order to ensure that they are kind of maximally effective in future enforcement efforts. And there are a couple different strategies that I'm going to talk about in this area. You know, there are a lot of analytic tools that have varying degrees of power. We actually, internally, because this is a topic that comes up so frequently, we've made a substantial investment in terms of developing some of our own internal analytic tools that allow patent holders to evaluate their portfolios and try to figure out which are the patents to maintain. And I'm going to talk about a couple of different strategies that can be implemented in that regard. So first of all, one thing that many patent holders will look at is an evaluation of forward references and trying to identify, when they're making determinations, which of the patents that are up for maintenance or potential non-maintenance decisions are actually frequently being cited. So this is an output from our internally developed pinpoint IP analytic tool. And in this tool, what we're able to do is to look at a client's portfolio. In this case, they had a very large portfolio, and look not simply at the overall number of forward references, but look at where a given patent is in terms of the percentile ranking for its forward references when it's controlled both for age and for art. And that can be very effective. So in this case, what we see is this particular patent holder, when we're looking across the entirety of their portfolio, had 1,282 patents that were in the 90th percentile or above for their age and their art in terms of forward references. So when making determinations about which patents to maintain, there was certainly this client placed an outsized focus on those patents, wanting to make sure that whether or not those patents correlated to a product that they were currently offering, they certainly wanted to make sure they were taking a hard look at those patents before making a decision not to maintain them. So that's a determination based really with a focus across all citing references, or citing applications, where they're, which patents in the portfolio are cited very, very frequently, again, when controlled for age and art. Another strategy that many patent holders have, though, is to look much more granularly at who is doing the citing. So a couple of examples of this. This is a table we compiled in helping to support a client's effort, where they looked again across their entire portfolio with an eye towards identifying who within their licensing target base were actually doing the most citing, and which patents and how many patents were they citing. And then we drilled down more particularly to a particular key competitor and looked at which patents is this key competitor citing within a relatively short period of time. So this is simply going back a 2-year time period and looking at which patents were being cited most frequently by this key competitor. These patents, again, as the client was then going out and making the determination which patents should we be maintaining, these patents were a key focus. And whether or not these patents were tied to a key product or otherwise considered core patents, they made the decision that they would maintain these patents because they provided either a key focus for a licensing campaign or a key defensive shield for any potential dispute with this competitor. A more complex and potentially very insightful analysis that can be done with patent analytics is to look at not just the number of forward citations and not just how frequently a given patent is being cited by competitors or key licensing targets, but looking to which patents are cited across the broadest range of technologies. This was an analysis we did, again, working with a client who had a large portfolio and was evaluating which patents to maintain and which might be worth pursuing as part of a licensing campaign. Where might we have some targets for a key licensing campaign? Now, like many patent holders, they had a very good read on what the activities of their key competitive set were. Their focus was on identifying patents that actually were cited across a very wide range of technologies and offered an opportunity for non-core licensing. So not licensing to a direct competitor, but licensing in other industries. So what we started with was looking at across an entire technology sector. So we were dealing with a patent that happened to be in a Tech Center Unit 1610. And we did an analysis that's reflected here of a curve looking about the number of any patent, the number of times any patent in that technology center unit was cited in different technology centers. So for example, how often do we see patents that are in that 1610 technology center for the patent owned by the client? How often is that cited, for example, in Tech Center Unit 37D or in Tech Center Unit 1620? There will be different correlated numbers here, but there's an expectation across all technologies as to how often that type of citation will happen. We were then able to look more closely at a particular patent held by the patent holder. We saw that if we look across that curve, in 2 technology centers, we actually saw substantial deviations from what we would expect in terms of that. So as the client was considering, should I continue to maintain this patent, and should I look for potential licensing partners, we saw that this particular patent is cited much more often than would be expected in 2 relatively unrelated technology areas. In this case, Tech Center Unit 37D and Tech Center Unit 37E, which covers medical instruments. So here was a patent, this was through the use of this analytic assessment, we were able to help the client identify an opportunity to license to a non-competitor outside of the core business by focusing on entities that were citing in this space much more frequently than would be expected. These are simply 3 examples of how analytics can be used effectively to identify where there might be value in a portfolio aside from core value that's tied to the products that are being monetized by the patent holder. There are certainly many, many other approaches that we've taken and discussed with clients as they're trying to make that evaluation. I think the net determination here is that when making the determination of which patents to maintain and how to allocate your patent budget, it can be very effective to look outside of the business operations of the patent holder to clearly assess where there might be value in the portfolio as indicated by any of these analytic measures. So with that, we've reached the end of our prepared remarks, and we have a number of questions that have been sent in, and I'd like to, and unfortunately we have just a little bit of time, so I'd like to take a moment to address some of those questions. So one of the questions came in from a listener, and it's directed to Tim. And Tim, in your prosecution practice, can you describe how clients are adapting to the changes introduced by the American Invents Act?
Sure, Chris, and I'll be brief because I think we're running down on time here, but we're still seeing a high emphasis on speed to filing. Our clients are looking at trying to shave off time off of those filing from the time we get the disclosure to the time it gets filed. We're seeing clients that are also putting bigger budgets together for patent searching, and a new thing is coming back into play, which we haven't seen in a while, which is clients that are really getting ready for the AIA and want to be AIA progressive are basically asking us to use our discretion to help them get the better rights, and we're being given permission to deviate from the filing guidelines. We're not a slave to the filing guidelines as much, because they understand that sometimes the filing guidelines can create problems and not just solutions. So in the new world, we're looking at prior art, we're looking at speed to filing, but we're also looking at discretion.
Okay, so with that, we've reached the end of our time. I'd simply like to close. Again, thank you for your participation. Unfortunately, we weren't able to reach all of the questions during the webinar. We will endeavor to respond to these offline, and we appreciate the questions that were sent in. The last thing that I wanted to address is that this is, again, a multi-part webinar series, and we would certainly invite you and hope that you'll be able to join us for the next in our series, which will address changing strategies for patent enforcement and licensing, the next step in the phase. And with that, thank you very much.
Thank you. Thanks, everyone.